This is the Mobile Home Park Lawyer Podcast with Ferd. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd.
Welcome back, Mobile Home Park Nation. Ferd here again today with another episode of the Mobile Home Park Lawyer Podcast. Today, I've been thinking about all the election stuff and all the drama going on in our country, and I thought, man, wouldn't I love to talk about the government today? So today we're going to talk about the government in the form of the Securities and Exchange Commission, the SEC. And specifically, it's going to be as it pertains to syndication, because there's a lot of things you can do to break the law, like jaywalking, maybe speeding by 1 mile an hour, and nobody really cares that much. There are other things you can do to break the law, and the government cares, and rightfully so. And obviously criminal matters are some of those, but today we're talking about SEC. I see a decent amount of offering memorandums and private placement memoranda, and have been involved in those from a legal standpoint and as a promoter standpoint. And I've seen a lot of them that are pretty wonky, pretty aggressive, if you will. I'm not going to call out certain guys who are illegal in these processes, but they're definitely out there. So if you're investing as a limited partner, you want to know who your GP is and want to make sure they're compliant. If you are the GP, general partner, / promoter, / sponsor, / syndicator, those are all the same thing. You need to make sure you know what you're doing, at least from a legal standpoint. If you don't, you need to hire legal counsel. Okay, I'm obviously biased. I'm a lawyer here, but this stuff is super complex. I've done some complicated tax increment financing deals, real estate contracts, leases, but some of the more complicated legal documents I've ever worked on are these private placement memorandum. And they're pretty verbose, easily over 100 pages by the time you add in, I think my last one was like 200 pages by the time you add in the operating agreement. You've got your business plan in there as an exhibit, your financials. Sometimes you'll include like a zoning appraisal or phase 1 report, a property management agreement. You're going to have things like your investor questionnaire to certify that your investors are sophisticated or accredited. And then you've got your subscription agreement where they commit to pay. You got your signature pages for the operating agreement and PPM. So pretty verbose documents. But today I'm just going to hit high level. What are the regulations concerning raising capital for syndications? And I think by now you know what syndications are. And the SEC is the regulatory agency that essentially promulgates guidelines and regulations, specifically pertinent to raising money for real estate. This came in about 1933, Securities Act, and basically it requires promoters to register with the SEC, unless there's a valid exception, and that's where the private placement memorandums typically come in, as they're an exception. And the two types of investors that are really allowed to invest in these are either sophisticated investors or accredited investors. Sophisticated is a little more aggressive. It's got to be somebody who has enough financial and business knowledge that he or she can evaluate the risks and rewards of the prospective investment. You can have no more than 35 sophisticated investors in a given investment. So this may be, I'm both, I guess. I'm an accredited investor. We'll get to a minute, but I would argue I'm a sophisticated investor because I have enough financial and business and legal acumen that I could invest as a limited partner. But somebody who has the same, education and intellect, but is a surgeon, may not qualify as a sophisticated investor as it pertains to a real estate investor. Now, the surgeon example, may very well qualify as an accredited investor, which is someone who has a net worth of at least $1 million, not including their primary residence, or has a net income of $200,000, $300,000 if married, and typically they measure that based on the last 2 years and an expectation in the subsequent year. There are some other ancillary definitions for if you're an IRA or a financial institution or some sort of corporation, but for most of the individuals I hear, if you're an accredited investor, you can invest in these deals. If you're sophisticated, it's a little grayer. And as a promoter, it's the safer best practice to just go with accredited only. And if you mess this up and you have even one person in there who's not, you can screw up the whole exemption for your offering. So you don't want to mess it up. And the key exemptions, really there's 3. There's 506B, private placements. There's 506C, general solicitation. And then there's crowdfunding. And I'll just say crowdfunding first because it's the simplest. And I've never done crowdfunding. It's a smaller limit. Like you can only raise up to $1,070,000 in a year. And basically, this happens typically through online portals. The SEC is kind of involved. It regulates this kind of intermediary. I don't see a lot of those, frankly. I'm sure they're out there, but most of what we see are 506B private placements or 506C general solicitation. So let's go with 506B. And this one, the key thing here is you're not allowed to openly advertise the investment. Basically, you have to have a pre-existing relationship with prospective investors. Typically, 90 days we recommended, at least 30 days of a pre-existing relationship. The more material and substantial that is, the better for you as the promoter. And the whole purpose of these private placements, by the way, so you don't have to register with the SEC and you can be valid and not get in trouble for raising capital. And with the 506B private placement, you can raise an unlimited amount of money and you can sell securities to an unlimited number of accredited investors. Again, sophisticated, you're maxed out at 35. If you have sophisticated, you have to make sure they get the documents that contain the information. I mentioned some of that kind of in the prologue here, business plan, financial statements. Basically, the PPM is also, it's a disclosure document. It's kind of like a prospectus, and then you have to give them these investors the same sort of information that would be in a regulated SEC, a prospectus. Like if you buy Coca-Cola stock, there's a prospectus. And it says, and this PPM says all the bad, scary stuff that can go wrong. Things like the market may change, our financials are not audited, we have not had these assumptions vetted by anybody else. We may be overpaying. We may lose our financing or not be able to raise enough capital, or management may die. All these other things. Or your tax situation may be different than mine. So on, so on. It's a big scare you away document, but it's kind of a safe harbor for the promoter. Like if you do this process, you're safe in that if the deal goes south and you didn't do anything fraudulent or misrepresentation or of that sort, you're more immune from liability. We all know what a limited liability company is, and it's supposed to have limited liability. Well, in a PPM, it's supposed to make the promoter have limited liability. There's some exceptions for crime and stuff like that, but for the most part, it gets the job done. So again, the key is no general solicitation or advertisements under the 506B. Under 506C, general solicitation, I think you probably figured it out by now, but the difference is you can publicly advertise. But again, that's if all the purchasers are accredited and you take steps to verify the purchaser's investor status. So you cannot have sophisticated people who are only sophisticated but not accredited in the 506C. And if you do a 506C, you're required to file a Form D with the SEC within 15 days after the first sale of securities. Basically, this just lets the SEC know who's out there doing this, who's out there claiming to be exempt, and they can regulate it. And by doing this, you're exempt from state registration, but however, some states still have the ability to require you to give them notice, the courtesy filings, and frankly, to collect fees. So 506B, 506C, they're fairly complicated, but it's kind of the name of the game if you want to be a syndicator or promoter. If you're doing stuff like you're trying to do it in just a plain old LLC, like, it's Ferd the promoter, and I'm going to bring on $1 million of private equity. I can't just do that in an LLC. If it's like me and my dad, and we're just sitting around and we're partners, and we're like, hey, let's do this deal together, I can get away with just an LLC, just me and dad. But basically, once one party starts to get paid or starts to have a disproportionate share, as syndicators typically want, some asset management fee, some property management fee, an acquisition fee, the promote I talked about in a prior episode. You get typically a limited partner gets a preferred return, and then there's a hurdle. Once that preferred return, say 8% is met, the promoter gets 30%, the limited partner gets 70%, and you can change those ratios. It's negotiable. You can have different ratios for for things from cash flow, from operations, from dissolution, from liquidation, from refinance, from disposition or sale. All of those things. And then also you can even, you want to talk to your CPA on the cost segregation tax benefits, but you can even have some ability to modify the tax benefits. That gets more complicated with qualified non-recourse debt, and I'm not going to get into that today. And I can hear my CPA looking over my shoulder saying, don't get into this stuff. You're not the CPA I am. But I've paid enough CPA fees over the years that I feel like I'm almost there. But I'm not, so don't let this is no accounting advice, frankly, no legal advice. I think I have to say that too, has been offered in this podcast. But ultimately, that's the high-level regulation on these three categories. In general, another question that I'll cover in a subsequent podcast here in a minute is, what if I have someone else raise money for me? How can I pay them? The short answer is you cannot pay someone to raise money for you unless you are a licensed broker-dealer. This happens all the time. I've been offered this on, 3 or 4 occasions. Hey, you want to raise money for my deal? We'll pay you 20%. It's like, no, that would be a felony for both of us. So don't do that. I'll get into that more in the next podcast. Until next time, have fun, be smart, God bless.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.